All right, Greg. Well, good morning. Today
Morning, sir.
we are going to be talking about what is a threat. And we're doing this sort of using a current case that we just heard the arguments for at the Supreme Court level. And the Supreme Court sort of has to decide in this case that I'll get to in a second is when is a threat a true threat? Now, we've talked about that from a different bunch of different perspectives, meaning if you feel threatened, you're going to act as if you are threatened. There's no
Yeah.
difference between that. But we see people use different, terminology like threat indicator, which you know me, I don't like things like that, or, but
Right.
they're trying to articulate something that can't always be articulated without a defined context and without further explanation, right? You can't just say,
Yes.
well, this is a threat because if it is, then it's so obvious. The person pointed a gun at you. Well, you don't need to get into what that is, right? That's very clear, obvious. Anyone would understand that. You've met some sort of lethal force, a threshold. So it's either so obvious that it doesn't need a name, or it's something that people are trying to use. So with this case, I'll jump into if unless you want to say anything before I give
No,
the
no,
give the
no.
case
Great assessment, by the way.
because there's a bunch we can get into, and I want to give everyone the background of this, and of course I'll have links in the episode details for you to read up on it. But here it is. So this is just being heard out, I believe, in April at the Supreme Court, and so they're revisiting a question the court has never answered called "When is a threat a true threat?" So this case involves Coles Whalen, a singer-songwriter from Colorado, and Billy Counterman, a man convicted and sentences to 4.5 years in prison for stalking Whalen and making true threats against her. So Connerman's messages went over a series of a few years. The police estimate he sent over 1,000 messages to the singer that ranged from affectionate to angry and aggressive, and gave the impression that he was watching her. So at one point, Counterman inquired about her mother after Whalen had just paid her mom a visit. Another, he wrote, "Die, don't need you." Another message he wrote, "I'm currently unsupervised. I know it freaks me out too." So Counterman also served two jail terms for far more explicitly violent threats against his ex-wife and family. And what Whalen said, right, this kind of like ruined her life, basically. She was
Yeah,
completely
absolutely.
consumed by it. She said, this is one time she was on stage. He wasn't even there or anything. She just started thinking about it. "I thought I might be having a heart attack. I had to leave the stage, which I'd never done in all my years of performing. When I went backstage, I mean, I just sobbed for an hour. I felt horrible. I thought maybe this isn't worth it. Maybe I shouldn't continue." She stopped performing for a while. This is something that she didn't just have to put up with and could hire a team to go do, right? This was severely impacting her life. So the legal case here is the question is in this case is whether the definition of a true threat is in the eye of the ordinary reasonable beholder. So in this case, in Wayland, in her eye of what a threat is, or in the eye of the writer of the messages. So is it how the message was received, or was it the intent of the message? So the lawyer, John Elwood, who is representing Counterman in the Supreme Court, points out that his client has been diagnosed with a mental illness and didn't know he was frightening Whalen. So that kind of gets into mens rea and it gets into a whole bunch of other things. But
Yep.
he's saying there was mental health. He didn't understand that he was threatening her. And he said a true threat standard that considers the speaker's intent is necessary to avoid criminalizing inevitable misunderstandings. So, and his point
Great
was,
line.
yeah, his example was, if you hit someone accidentally, you may bruise that person, but that's not a crime. But if you hit someone on purpose, that's a crime, right? So, and he said in the internet age, and this is true, words on the screen are divorced from context because it's important to remember a lot of this happened over Facebook, right?
Right.
So the First Amendment, he contends, doesn't allow the state to punish a person based on what a reasonable person receiving a message might think. The question is what the speaker intends. Okay, so that's his argument. So now Colorado Attorney General counters that under Colorado law, the question is whether an objective person in the situation of the victim would feel threatened. And he notes that's what the trial was about in the Counterman case. So he's saying this is why it went to that trial and why he was arrested and jailed in Colorado. And he said, since the founding of the Republic, we've had threat statutes that have allowed the prosecution of threats without regard to the specific intent of the person making the threats. And he said he points to different briefs filed by victim rights organizations, different studies that shows for the victim, the psychological effects of the threatening behavior is frequently far worse than an actual assault. And he said, we live in a time of rising demonization and threats of physical violence and actual physical violence. It's important that the law be able to respond. So the discussion here I'll throw a bunch of questions here that we can get to, Greg, and is what does the prosecution have to prove? Does it have to show that the defendant intended to frighten his target, or is it enough to show that his words would have the effect on a reasonable person? Because this gets into what is the definition of a threat. They're talking about mens rea, the subjectiveness of experience that we always talk about. There's intent and subjective intent. There's perception. There's even a mental health angle in here, and so there's a lot we can get into here. Those are the big points, but we'll probably get into a bunch of different areas. But I at least want to give everyone the background of the case of why we're having this discussion, because legally defining what a threat is very difficult to do outside of a given situation, right? You have to give an example and say, in this example, this is what it means. But in that example, it might mean something different. So that's everything up front.
No, it's such, look, we could do a month of discussions, an hour at a time, on the topics you just brought up.
Right.
And there's so much that's in there. So let's give an example. Let's go outside big to inside small.
Okay.
So there was a caper in Canada where an incel killed, and during that trial, it was brought up that the argument was that the incel is guilty of terroristic threats and terrorism. This is a crime of terror, okay? And the reason that things like that happen is because we assign value to words that have already been defined, okay? So, and the reason I want to bring that up, and that's a side argument, gosh, that's another podcast. When the Attorney General in Colorado was talking about, he dropped the word in the sentence specific intent. Well, the reason he threw that in, and most pundits, unless they're legal scholars, don't know this. Well, there's specific intent and there's general intent, right?
Yeah.
So what's happening is sometimes a standard is set. Like, for example, the Supreme Court this term revisits a question the court has never answered. The court has answered it many times.
Right.
There's case law. What a threat is, what a true threat is. Go ahead.
No, I think what people kind of mean by that is like there's no legal definition of what a threat is, but there's case law.
There's many definitions of threat. And in legal terms, there are cases where people use that term over and over, which now becomes precedent. But the idea is that each case has to be based on its individual merits. While you can cite precedent, the idea is this case precedential? Yeah. So the idea is that, look, first of all, the Attorney General in Colorado, the line, the psychological effects of threatening behavior is frequently worse than the actual assault. I wrote that down while you were saying it. That's huge. Okay.
It is.
So I also want people to remember, so I'm going to lay more facts on. If you've ever listened to Cole's Waylon, she actually wrote a song about the Billy Counterman incident. We're not talking the Foo Fighters. We're not talking, Mick and the Stones. We're talking about a good entertainer from Colorado that might fill a venue of 100 to 300 people once in a while.
Yeah.
Okay. This is why I love the Supreme Court, because what the Supreme Court is doing is the Supreme Court saying, listen, this case is important enough because we haven't fully defined a true threat.
Yes.
And the argument doesn't matter that this person isn't going to impact 1 million people with her song. It's that she was personally impacted.
Yep.
And the law was there and it's supposed to protect her and it didn't. That's the argument, right? So the simple argument is you have a standard called the reasonable standard, which is would an objective person in that situation at that time do the same thing, right? Or think the same thing or react the same way. Then you got the truist, I'll call them, where you must demonstrate intent. Intent must be demonstrated in the threat. Well, a good dodge for intent being demonstrated is saying your client doesn't have the mens rea because they're not well educated or they have a mental illness.
Yeah.
Right. So that's a dodge a lot of times.
Of course.
And I also say you got to take a look. What's the best predictor of future behavior? Past behavior. And in this case, Billy Counterman did the same type of behavior with previous wife
and went to and was incarcerated for it.
He went to jail for it, so he knew better.
Yeah, so if you
He
made that
knew
argument back
or should
then,
have known. Exactly.
yeah, that's
Then you
one
would have had
thing.
a chance.
But now since you've already been established in this
Because
specific
what is it?
case, yeah,
What do we call it? A pattern of behavior.
yes,
So the idea is that when you're taking a look at this specific series of criminal activities, it's hard not to say that there were threatening behaviors, and that the benchmark for that is that Coles Whalen was a mess. She was a shit sandwich. She would go on stage and constantly be fearing that he was going to show up. She didn't know if he was in the audience. She didn't know if he had enlisted the aid of others to do stuff. And Brian, nobody has the right to put you in that type of fear.
right,
So here's a companion argument. If you felt threatened or in fear when you went to a movie theater because of the nature of the film, and it made you fear that you were actually in danger for something, even if it was a documentary, you could always get up and walk out of the
yeah, and
theater and change your situation, right?
right,
But in this one, you can't, because counterman, and the key thing is that other cases sometimes cover things for you. So in stalking, his behavior was criminal stalking as well, right? And you said 1,000 messages over a weekend. You and I recently read a caper where it was 30,000 messages from
yeah,
Friday to Sunday. Okay, Brian, that type of behavior
yeah,
and acting up versus acting out is a good point to bring up here. He was given, counterman was given numerous chances to cease and desist. He was
hmm
given numerous chances. He was given a message from the court early on in his first marriage that this behavior will
is
not stand.
unacceptable, right?
You see? So here, I don't think that this is one of the first times I'll say that the general intent is enough as long as the reasonableness standard is met. So if you have enough people that would say, yes, I would feel threatened by this behavior, then it becomes a true threat. And it's one of the first and few democratic arguments that I will make about the law. But this is a good one for that specific argument. So we might
So
argue about that, you and I.
yeah, well, and here's what the Attorney General for the state of Colorado brought up some good points
Yep.
and saying, well, and this is where we're going to see more of these cases, because what his not only is he making the argument, is counterman's attorney making this argument, okay, there's a mental health issue in here.
Yep.
He's also making, if you go listen to his arguments at the Supreme Court, he's making a whole bunch of First Amendment arguments.
Yes.
And okay, but that one, and I get that, because this was also, like I said, a lot of it's done over social media, so they're both acknowledging the fact that, and there's other cases, and there will be more as we move more
Yes.
and more into social media, of what constitutes a threat, what constitutes incitement, what is it.
Exactly.
So that's great. I love seeing that play out, because it's important, it's already established, so how are we going to interpret it in the digital age? And because, especially with the incitement stuff, because
Yep.
this imminent, lawless action, which is part of
Imminent
incitement,
lawless action.
it has
That's
now
it.
changed over time.
Yep.
1800s, it was very different. Now something can be imminent. A tweet can be imminent and start
Yep.
the fire. It took longer time back then. So that's part of what's going on here. And he brought up the point where, look, psychological and emotional abuse is oftentimes worse than physical abuse, or on
Brilliant
par.
argument.
And
Yep.
so which is shown, but that kind of wasn't always, people didn't really acknowledge that or
Right.
know that. Really, it was always like, well, he never put his hands on her. It's like, well, Jesus, yeah, but he's terrorizing her life, and she's psychologically traumatized for the rest of her life. So there's a whole bunch of those arguments in there, and this also gets into that what we talk about a lot, and how perception is reality. And that's the thing, it's not, intent always matters, of what the intent was, but you have to take into account the other end of the reception of that message, and
Precisely.
what a reasonable person would think in that time, because that's constantly playing out, or we see that play out on the news or on social media. But a lot of that, what people say, well, I was threatened, it's like, well, no, Were you though? Or,
Right.
should you feel threatened by words? Because words matter, but they're not as powerful as actions. But if you're doing both of those, right? If I'm making those threats, Greg, and I'm showing up at your concerts, okay,
Yep.
that's not just words anymore. Okay, that's me
Right.
making a physical presence. And this is the part that interests me because they obviously brought in all the First Amendment stuff. And you know what? Like that the Supreme Court's typically been pretty clear on that.
Yes.
There's exceptions that have been kind of changed over time, and you go back to even what was it, Shank, right? So
Shank
Shank
is
versus
a
the United
great,
States. So
great landmark case.
for anyone who knows it, this is during
Yep.
World War One. Shank was passing out, criticize flyers, mailing stuff out, criticizing the draft at the time, criticizing the war. But due to some legislation that had passed, I forget what it was at the time, but there was some national security legislation that kind of made what he said illegal, and the Supreme Court upheld that and said, yes, it is illegal what he did because of this law that is now on the books and because it was during a time of war. And that's also where you get the famous a line from which even the justice that said it later on kind of regretted saying this because it's a horrible description where he said the most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic. Now everyone uses that line and it's the worst line ever. Like you
Yep.
can't yell fire in a crowded theater. Yeah, you kind of can. But the idea that that gets into what is incitement, right? And
Right.
incitement typically falls under it's intended to cause and likely to cause imminent lawless action, right? That your words are going to fall under that. So all of these cases then start to kind of build up and build that standard of what it means. And he's arguing that under a free speech, right, under a First Amendment
Yeah.
right. And we're
That's the
seeing
mistake.
right, and we're seeing that play out over and over. And oftentimes when people talk about free speech and what they think is free speech is usually pretty wrong. It's typically what I've seen is people like their speech to be heard and not
And
other
be free.
people's
Right.
speech
Right. Right.
and not other ones. And it also doesn't mean you're free from the consequences of what you say. It just means you're free to say it. But that's the part where I kind of like it seems like it sort of got off the rails a little bit in this
Yeah.
case. No, we're not off
Yeah.
the rails, but I didn't agree. But this goes back to again, everything we talk about is what is a threat and how do you articulate what that is? It's based on the circumstances that you're in and that reasonable person. So there you have to take into account sort of the intent of the individual and how that was received, right? Because let's say okay, someone wants to, I'm staying at a hotel, Greg, and I'm in there alone in my room, and someone wants to, they're just some punk kid that wants to mess with people at the hotel. And at 2 in the morning, that kid pounds on my door and says, I'm going to come in there and I'm going to get you. Okay. I'm going to be like, all right, what the fuck is this? This is annoying. You're waking
Right.
me up. Now I change that up. Now my wife is at the hotel alone at night with our daughter in the room, and that same thing happens. That completely changes the dynamic in that situation
Right.
because of even though that kid's intent was the same, the victim on this end, the person receiving that, has a completely subjective experience and it's completely different. So does that change, how you can
Of
prosecute that,
course it
what that
changes.
means? So
Uh,
that's what I'm saying
yeah.
is
Yeah. No,
these are
no,
the
you're
factors
exactly
that
right.
are important.
You're spot on the argument, but that's why your focus can't be on First Amendment because First Amendment brings in
Yeah.
hundreds of years of case law where your argument is muddied. Okay, it's not a clear message. I think that a counterman's defense would be much better by saying this instant, while regrettable, was caused by a lapse in mental judgment
Hmm.
brought on by an illness or injury or trauma, right? Because you can
Yeah.
use the first marriage as trauma and his incarceration there clouded his judgment further, Brian. That's a good argument. Why?
Yeah.
Because now you can't bring in Shank and
Yeah.
show that, over time. Look, this is what people don't understand about America. In America, the Pony Express was only around for a year and then it was gone. Why?
Yeah.
Because we didn't need it anymore
Yep.
because other faster means of communication came in. P.T. Barnum created the solid Muldoon. Well, the first time he used it was in England, and he put Portland cement, an antler, a rib, and like a foot from a chicken into a big mix and made it into a sarcophagus-sized human. And they dug it up, and he paid a bunch of people to say it's the most amazing find he's ever seen. and he did it again 3 or 4 months later, okay, and did it on the East Coast of the United States and called it something different and said, "Oh my God, we found the connection. This is the connection between apes and man and everything." Both times made hundreds of thousands of dollars on the discovery. What was the difference? The difference was time, because you had to take a boat to get to America, so news didn't travel that fast. So
Right.
there was no imminent lawless action
Right.
in something that took that long to get. And look, before the railway, before the Pony Express, took a long time. So if I wrote, "I shall smite thee when I see thee" in
Yeah.
California, right?
Yeah.
It didn't
That's
have the same kind of feel,
I
did it?
might
You
forget
know,
I
it,
wrote that by the time I actually
it's
run into you.
exactly, or die of scurvy,
Yeah,
right? Or
exactly.
rickets. But so the idea here, Brian, is that what you have to consider now is that we're talking credible threat,
Hmm.
okay? A true threat. I know they're going to change the wording when the Supreme Court gets it, and the Supreme Court is going to come down with the standard. Why do they have a standard? Because if you're polypurebred as a victim and anything scares you, a loud fart causes you distress. You know, you passed
Yeah.
out when you heard a shopping cart tip over at wherever. Okay, that's going to be a different standard for thinking that the threat was credible, because you're basing it on the person, the intended victim. You can't always do that. The state has to step in sometime and go, "This is what a victim is. This is how you can
Right.
tell what a victim is." You get it? So they're doing that in our best interest because it'll cover more people and it'll protect more people. So the uniqueness of Coles Whalen's argument here, that she was personally traumatized, that has to go by the wayside. What has to come to the forefront is that it's not Billy Counterman, it's any person
Right.
that does this behavior will be guilty of this crime, whatever that crime is going to be named going forward. You get what I'm trying to say? Because the credible threat put this person under mental, physical, monetary, financial distress.
Hmm.
You see what I had to sell my house for less money to move because Bakersfield just became too hot to handle. That's what we're looking for in a case like this, that this is going to set a new standard for how we look at certain cases. And I go back to that terrorism argument. Listen, when you start naming things
Right.
and you start pulling things out of the box, then it becomes too specific. The law can't be too specific. It must protect all of us. And it must protect all of us equally. And it must protect Billy Counterman as much as it protects
Right.
Coles Whalen. Yeah. And that's a crappy argument, but it's true.
No,
Right?
and this is why, we like cases like this, and you
Yep.
brought it up too, because she's not some super popular singer. This
Nope.
isn't Taylor Swift, who has a full team, and actually like Taylor Swift literally has you know cameras and biometric software that scan people that come into her show, because she has a database of known stalkers, and they can just compare that to a database, and they can know right
Yes.
now, all right, one of these people is here. It might be someone she already has a restraining order against. I mean,
Yep.
but this is a massive, massive celebrity you're talking about right there, with
Yes.
the resources to do that. Well, I can't do that if I'm just regular person on the street. I don't have that
Exactly.
ability to. Now I might, but I still might, even that regular person on the street, you still might be dealing with the same type of threat that
Exactly.
Taylor Swift is. And that's a good point in all of this. And it's an important, anytime I've had anyone call me and ask me questions about this type of stuff, or maybe it's a behavior from someone, and I took, we just do the same thing, get the yellow pad out, write down what's going on.
Yes.
And especially, when it's a guy doing something with a woman, and I'm like, okay, did you file a restraining order? You can get a temporary restraining order, and it'll go up, and it's documented, and you can present, this is everything that's going on. They're like, well, no, I don't want to do that. It's like, well, then everything you told me about, none of that's actually happened. And it's like, well, what do you mean? I was like, well, it's not documented. No one knows that this
Yes.
is going on. So therefore, if he does something, that will be, in the eyes of the law, under the court, the first time this ever happened. That's how it's going to be looked at. I go, if you don't do these things prior, or if you don't document it, right? All of the is why how many times we say you have to document something that's going on. You have to make note of it, right? So that you have some sort of legal ground
Absolutely.
to stand on. And that all falls into to this case as well. And it does go back to there, things that we always talk about, no matter what the case is or what the situation is, and that words matter when you do articulate something.
Absolutely.
Just calling something a threat, that means something. Craig, you and I have a different definition of that word, even talking about the same thing
Absolutely.
right now. So
Absolutely.
it's what is it that made it a threat? How
Right.
was this a threat? And if you can't articulate that, then either maybe it's not really that big of a threat, or you have to get better at articulating it. This is kind of
This
makes sense
is,
of yeah.
it's on point, Brian, because this is what lawmakers are supposed to do, because the nuance of the law takes time. And that's why Congress is supposed to be sitting around fighting these battles for us. And I'll give you an example. If they were involved in an intimate relationship, it changes the
Yep.
dynamic. If they're familial, that changes the dynamic. If they're an employer, that changes the dynamic. That's what Congress is supposed to be doing every day when they go to work, Brian, is figuring out those nuances and building a subset of rules that are simple enough to follow, then challenging those rules to make sure that they work for everybody. And I'll give you an example why cops hate this, because Coles Whalen is known to Colorado law
Oh
enforcement
yeah.
because she came in over and over and
How
made
many
the
times did
complaint.
they call? Yeah.
Right. And now they're going, oh, here we go again with Coles Whalen. She's a victim, folks. But
Yeah.
the idea is that when you're a cop and you got like really big cases to fry on your,
Yeah.
front burner, last thing you want is Coles Whalen calling and going,
Yep.
this guy made 7 more phone calls. Now, if that sounded like an assholish remark, understand that it was intended so. But that's the truth of the matter. And I'll give you an example. So Billy Counterman says, hey, listen, Coles and I were intimate for a good long time. And now, it's just typical lovers breaking up. So the cop leaves and goes back to Coles and says, hey, listen, he's telling me that you guys were this and that. And she goes, nothing's further from the truth. I've never met the man in person, right? So
Yeah.
that scrum starts, Brian.
Yep.
And now there's the belief cycle that goes on, just like with sexual assault and rapes and
Oh
all those
yeah.
other things
Sexual
where,
assault's a big
right?
one. Yep.
Okay. And now all of a sudden, Billy starts intimating during some of his threats. Billy Counterman, the alleged suspect here, starts saying stuff like, hey, saw you last night and that was amazing. And that now Coles Whalen doesn't know if he's actually in a position to make those or if it's mere conjecture, if he's just lying, if this is a fantasy sequence, right? So the idea is be a cop and be writing that report. Okay. There's a lot of allegations, there's a lot of paperwork, there's a lot of other thing, and now you get a protective order. Well, the great thing about what Brian was telling you folks is once you document it, once you have a case number and a case file, and you get a protective order. Now, every time Billy Counterman comes in and does something, he's violating the law. He's been told not to. It's like a trespass. He's been told, stay out. You know what I'm saying?
Yeah.
And he came back in so you can get hooked. That doesn't make it easier in the long run. The idea is that Coles Whalen, we have to envision her as you and me, but we also have to envision Billy Counterman as you and me that doesn't know better in this instance.
Yeah.
So we have to teach him. Okay. So how do we teach people that their behavior is out of line? Well, we used to put them in a penitentiary and
Hmm.
make them be penitent, give them a spoon and a Bible, right? Well, we don't do that anymore, do we? And we talk about rehabilitation. Well, Billy's pattern of behavior, Brian,
Yeah. It
is
shows.
is
Yeah.
yeah, it shows a lot. So is he rehabilitatable? And is this an offense where it's better served by the mental health community than by the law enforcement community? And the Supreme Court's going to answer all of that. But remember,
Yes.
the Supreme Court doesn't write policy. The
No.
Supreme Court is going to say, here's what's important, focus on that, and send it back down. You understand that, and I want our viewers to understand that and listeners. The Supreme Court will say, yes, this is in line with the Constitution and the amendments to the Constitution. And we suggest you take another look at this part of the case because the answer is there. We all agree that that means more than any of the other rhetoric there. Now, they could come with a definition. So the Supreme Court could refine and define threat, credible threat, true threat, right?
Yeah.
But they're not going to make a specific decision where they say part 1, part 2, part 3. That's up to lawmakers, Brian. And
Yeah.
so this case screams for some congressman in Colorado to come up and go, we can't ever have this happen again in Colorado because this poor woman is ruined. I mean,
Yeah.
if you read anything she writes now, she's not the same person
No.
early in her career. And she didn't ask for this, Brian. She,
No.
she she was targeted by this guy, right? So I think that's an important standard too. What comes of a SCOTUS case is hugely important to all of America. Even though this feels Colorado centric, Brian, it could be your daughter, it could be your brother, it could be you that's feeling the pain. So, and we also want to state that we want what's best for Billy Counterman. Now, if that's additional incarceration, we want that. If
Yeah.
that's additional mental health outreach, Brian, we want that too. And people go, well, how can you want that for? Because if Billy's really truly a mixed up kid that didn't know what he was sending, he needs help. Okay.
Yeah,
But if he did know what he was doing, and it's likely that he did, Brian, he
I
needs
think
a good
so.
spanking, right?
Right, right, and that again,
Legally.
that gets into the I mean that and that's what comes next is how we handle that stuff is not always great, and
Yep.
he's shown now how many times has he done this? How many what did it take for him to originally get incarcerated for
Yep.
those types of charges in the past, and then now he's doing it again. I would sit here
900
if
calls in,
well
Brian, something had a trigger and say,
that
holy crap.
that's the thing is that it's
Yeah,
to me, if looking at this, I would go, well, it's clear he's not learning from his past mistakes, and he's been told this
exactly.
before, and it's going to continue until there's some major intervention. But that gets into kind of the how we deal with it societally, and what we mean by incarceration, and what we think people should do, and all that. But that's constantly changing and getting played out as well. um there was the other thing you kind of brought up with your example of the investigator or police officer going, oh, here we go, it's
Yep.
counterman again or whatever.
Yep.
That's kind of the other the other kind of part of this case that I want to discuss, because it's how we take in information when someone's reporting something,
Yes.
right? Meaning, I look at it anytime someone says, whether it's us doing work or someone just personally saying, hey, here's what's going on. you know I'm not in that moment trying to figure out whether they're telling me the truth or what's really
Right.
happening or anything. It's just a very much, okay, I got a blank piece of paper here and I'm going to fill that up with what you say, right? And that's it. I'm not going, well, did you know, what did you think, are you sure you really thought that way, or really? No, it's like, okay, you tell me what you think is
Right.
going on. It's not my role in that moment to figure out the situation. It's to what? It's to just flip that switch to receive, take it all down, and
Right.
then go back and go, well, let me take a look at this. Let me ask you a couple questions. But a lot of times we come in with that, or I know what's going on here. I see what's happening here. And this is, and
Right.
so we start to miss those sort of indicators, or we miss what's important. And that's just natural. That's human nature. We do that. We want that
Of
conclusion.
course.
Whether, we were just on the Distinguished Savage podcast talking to our buddy Walt, and he was talking about,
Walt Settlemar.
communication issues with his girlfriend, going, well, I'm already trying
Yep.
to give the answer and fix it. I go, yeah, because you're not you haven't flipped that switch yet to receive. You're
Yep.
already in problem solving mode, and you haven't sense made yet, right?
Yep.
You already go. And sometimes that stuff, it plays out in these cases, or it plays out in other cases, but it gets into, the back to, what is a threat? Well, I didn't think it was a threat, or that's not a threat. It's like, no, it is to that person. It is in that place and time.
Precisely.
And understanding that, it gets a little complex, but we have to allow for that. We have to know that those are going to be different. There is no one standard for what that means.
That's why, look, I got roped into to reading everything that Calhoun and Weston put out, and buying their high-priced threat assessment management strategies, threat assessment and management strategies book, which is more expensive than any book I've ever purchased. I read it in an hour, and then I had buyer's remorse. The reason is that when it comes to assessing and classifying threats, we're broken. And what I mean is that we've got this whole assessment criterion that all these doctors write about and they put together, and they say, this is how you assess. But because it doesn't cross over into law enforcement or your legal rights, there's a disconnect. So what they did is they were talking about, Calhoun is the doc, and Weston was a former copper that's now a doc. They were talking about howlers and hunters, and how some people howl but they never act, but the hunters are the ones that are going to act. And a long protracted case, our buddy Brian Urich from Ann Arbor was talking about it, that the guy went and bought a gun, and that they tried to intervene by calling the guy's mom and saying, hey, would you turn over the gun? That's going to, lessen some of the severity. It's going to take the pot from boil and put it to simmer. And so they called the mom. The mom agreed to it, and it was in Warren, Michigan. They called the Warren PD and said, would you go over and pick it up? And the Warren PD coppers went over and go, if we pick up this gun, I'm going to have to carve my badge number into the side of your gun
Yeah.
that you bought. We're going to put it in the evidence room, and it's likely you're never going to see this gun before. And the mom was like, well, I really don't want to do that. And then the doctors are going, yeah, but your behavior would help put it back. Brian, this is why we need a
Yeah.
gosh damn definition from the Supreme Court. Because
Yeah.
if it was a credible threat and they could determine that the gun was part of the process, it's part of the intimate knowledge of this caper, and removing the likelihood of a weapon or a person purchasing a weapon had something to do with the assessment strategy and the classification strategy, then we have something. But we don't. We have two wheels spinning. We have the assessment and classification of threats over here, and then over here we have the legal, what I can do based on law. So, like for example, in Colorado, where this case started, the Counterman versus Colorado, the idea is that you have Colorado revised statutes. So it's a statute, and you go down and you go 12.2-107 says that you shan't do these behaviors while dressed as a chicken in a public location,
Yeah. Right.
whatever. And Brian, it either meets that, exceeds that, or it falls short of that standard. So the reason I'm busting up about threat assessment and management strategies, those are fantastic, but you're filling the page. You said it earlier. You're filling up the report with words, right? But what's the standard for getting something done? Now, in those same things, they'll say, well, sometimes you don't want to go to the court and get a restraining order because that might exacerbate the problem and make the person angry.
Yeah.
That's not true,
That's
and it's
not
not
true.
fair.
Yeah.
Okay. The idea is that, one, you got to bring somebody up on a radar, or they're not targeting. Okay, targeted rather. In other words, they're not in they're not on the lips and the tongue of the local police and the court system, right? So if Coles Whalen kept silent about Billy Counterman's actions, okay, and just lived with it, Brian, which a lot of people do,
Yeah.
and their entire life, their neighbor was such an asshole, kept yelling about the dog across the fence, and I swear to God, he came out that one day and had a gun. Okay, Brian, those capers happen every day, and nothing ever happens with it. And if they do, they're a log sheet where the cop came over and goes, I swear to God, if I come back here, everybody's going to jail, right? That's how they're mostly handled. That's not the way that we need to handle this, because this needs to be a benchmark, a landmark, so people that are being truly threatened, true threats, have recourse. And what's your
Yeah.
recourse? That you can go to a cop and go do something about this. Because I'm telling you, imagine being the fourth cop into the series and saying, and so you've made a report about Counterman before? Yes, it was in Aurora, Colorado. And what did they do? I don't know what they did, but he's still threatening. Okay, well, what do you want me to do? Can you hear that playing
Yeah.
out? Now,
It,
you're going to fault the coppers, but the copper doesn't care unless it
well,
meets a standard.
it,
He's not there to be a mentor. He's not there to be a coach in your life, and tell you what to do next. That's not what he's supposed to do. He's supposed to make a determination on the law, go to the detective bureau and say, hey, I think we got a caper, right? I feel strongly that we have to mention that, because it's a hard life as a copper, deciding what your real role is in that,
yeah.
in that
And well,
process.
yeah, they might not even know about any of the past incidents with this
Nope.
person's reporting. They're thinking this is the first time or first thing. And
Certainly the first time they're hearing it.
right. And that's stuff will happen. And the other parts of this too is when it gets into I mean, his attorney walked into this might fall under free speech realm and opened up
Yep.
that can of worms. And okay, that's where he wants to go with the case. That's where he wants to go with the case. But this is what I do see a lot now of people, behaving on social media, and
Yeah.
where you do have these sort of attacks in a sense, and people threatening or making threatening statements.
Yep.
And he brought up a good point. Just what you read on a response to a social media post it's very much out of context if you're just taking that and reading that out loud in a courtroom. You're going,
Yes.
okay, well that sounds much worse than it is, but in the context of this, I see you're angry at this post and you have the right to respond. That's what this platform is. Again,
Yep.
that's what I think the interesting part of the case is. I don't think they're going to get into that in terms of the ruling of the Supreme Court, because
Not at this level.
not
No. Right.
well,
Right.
because this case doesn't fit that mold. It's not
Exactly.
one that falls
But they're
under
going
that.
to cite it. They're going to cite, both
Um,
attorneys are going to cite that when you said, I will effing end you on an Instagram, that it was less powerful that when you said that in that hallway at the hotel while you were
Right.
banging on the door.
Right.
You see what I'm trying
Oh
to say?
yeah.
So they'll
100%.
bring that up to shine the light, Brian, but it's not germane to the case when it is going to be the conclusion of Counterman versus Colorado. I agree. I wholeheartedly agree.
Yeah, and this is also part of the reason we're having this discussion too is you know, this is kind of a semantic discussion because
Yep.
it's important with how we use words, and that's why it goes back to when I see things like the, you know, a threat indicator or a pre-attack behavior
Yeah.
or
Yeah. Yeah.
these, and they're, you know, sometimes someone's just trying to put words to something they've seen before, but it changes in every context, so you don't know how to describe it in that context other than a pre-attack behavior or threat indicator. Well, is it a threat? Is it not? It's like, well, that's a nebulous thing that changes with every passing second, based on
Exactly.
what's going on in the situation. So you can't jam a square peg into a round hole. You can't fall into that trap of when someone does this, it means that. It's like, well, no, it doesn't. It meant that the last time you saw it, but it
Right.
might not mean that right now. Does that make
No,
sense, Greg?
but that plus artifacts and evidence,
Yes.
and now the atmospheric shift that things are in motion that weren't in motion before, and that new constellation of elements coming together would tend to show that there's going to be imminent lawless action, Brian. I mean, that's why what we teach is legal, moral, and ethical,
Hmm.
because every culture on the face of the planet has what we teach as part of their legal standard.
Yes.
Okay. So this means nothing, but this and this and the confluence of that together, that generally means that you're going to be in trouble. Now, what other things would I have to see to make this an imminent threat, to make this so like the law talks about ability, opportunity, jeopardy, and preclusion, and we can talk about that in this context, because if I said Coles Whalen, were you in imminent jeopardy from Billy Counterman's threat? Well, no, I guess not, because I didn't know when he was going to strike. Well, now what we're doing, Brian, now that's that lexicon in
Yep.
court starting to fight us, right? So what we have to do is we have to come up with the right words for what type of peril or
Hmm.
jeopardy that Coles was put into. And if that's financial and psychological and sociological and physiological, Brian, that's what they're going to do. They're going to
Yes.
say if it meets that standard, then it was illegal action. Now, and I'll give you an example of this gosh damn security posture assessment horseshit that's out
Yeah.
there online right now. So I saw a video yesterday, and it was a poor video. And remember, folks, if you can record it, you can stop it, of a guy in the middle of a town hall. It's a medical conference. People are badged. They came in. They're paying money. They're at a convention center. And here's this table full of doctors. And they introduce the one doctor on the far right end. And a guy gets up out of the audience, walks all the way through the audience, goes over there and starts slapping this guy and yelling and saying, this guy slept with my wife and he's
Oh,
bad, and slapping the guy's trying to dodge and everything. And people are getting up. And the first thing that people do, they start pulling out their phones and recording it.
yeah.
Right? Other people keep trying to go on with it. Hey, sir, stop. Some people feel uncomfortable and walk away. Brian, when you're talking about assessing threats, if you're talking about doing it in the moment while it's happening, that's well too late. I get it. Asked and answered, Your Honor. What
Yeah.
I'm saying is that if you're going to host a public venue event and you're going to invite people to that, you have to have an internal protocol for what if this gets out of hand? What if this slides sideways? What if somebody gets up and says, by the way, you slept with my old lady in high school, and comes up and charges the stage? So here, when Coles made the decision to be a public entity with her music and host concerts, she had to know that she could reap the whirlwind. But it's not her job to rein in Billy Counterman. You get
No.
it? So that's the seesaw that we're on.
Yes.
With the
I,
doctor in the conference, he should have expected. He should have said to the people that are hosting the conference, "I'm planning on speaking to the conference because we don't know if this guy's a nut or not. The story hasn't come out whether it's a true incident that the guy slept with his wife or anything. It was just allegations and a bitch slapping, as they used to call it back in the Detroit streets. But the idea was, Brian, that if we speak, what's the number one thing we're doing with this caper that's coming up in New York? Who's our security? What's our inner perimeter? Who's going to be invited to the event? Why? Because we are responsible for our own safety, but so are you, venue. So are you, host. Yeah. And so In this, Coles Whalen had a reasonable expectation that she was going to be protected against the Billy Countermans of the world. The law let her down. So you see that. That's kind of
Yeah.
a precarious balance. It's a house of cards, isn't it? Because, you know, who do I blame? Well, I can always sue somebody when? After the fact, because you didn't assess the security requirements on the ground properly before we showed up. You
And
get my argument there? I
no,
mean,
no, and
that's another one.
I get your argument, and the reason why a lot of these cases, especially with the stalking stuff, keeps happening, it's not always the law, it's how these things are reported, how they're handled, and how
Yep.
they're articulated. And this is part of the discussion because, you know, like you just said, police officer shows up, has to take a report, or someone says something, okay, great, hey, there's not a lot we can do. You can go through the court, you can do this.
Yep.
And it's like, well, no, there is a lot you can do. You can document this stuff. Maybe not that individual officer, meaning it's not their responsibility. It's the victim can do it by you know by using this and actually
Yep.
literally documenting everything that's going on. Right, taking this from a sort of subjective to objective standard
Yep.
of what someone else would think, and really sort of going after it and staying on top of it because it's not it's your, like you said, it's your safety and security is your responsibility. But this person doesn't have the right to do this to you. And if you can show
Exactly.
how much they're impacting your life before it gets to this catastrophic level, or before it gets to the point where they may physically do something, you can show that, you can do that,
Right.
right? I mean, how many she could go to a therapist and they could document all the ways that this has
Yep.
impacted her life psychologically and sociologically and physiologically, right? And show this is the harm that this person's actions are doing.
Yep.
It's not then it's no longer covered by free speech or First Amendment, right? Because you don't have the
Precisely.
right to do that. And that's what I see in a lot of these cases. And everyone says, well, they're tough, and it's a lot of he said, she said. It's like, well, no, not necessarily.
Right.
Not if you really look into it, right? You can show who's doing most of this, and then who's causing the reaction out of the other person for them. So that's the thing is like, and because a lot of them, some of these cases, or a lot of these cases, are typically, a lot of times they know each other. The parties, both the offender and the
Yep.
victim, had some sort of past, like you brought up, whether
Yep.
it's a intimate a friendship, or they were together, whatever it is. And that's what makes them so volatile and so emotional. And that's what makes these so scary too, because those are the ones that can go off. And then to tie it right back into your town hall example, that's
Yep.
more likely what you're going to have at one of those things, where it's not someone coming in to shoot up the town hall because of a terrorist attack. It's no,
Yep.
you slept with my wife, I'm going to kill you. And then in the melee, I end up killing two other people and maybe myself in that situation.
Yep.
That's the most likely thing, or that's more likely than someone's going to park a vehicle borne improvised explosive device outside the meeting, right?
Right.
And those things we don't ever think about, because that's the insider threat. That person, that doctor in your situation, is the one who brought that guy to that place by his
Exactly.
actions outside of work, or his actions outside in some other context, brought that upon the community, right? Because
Yes.
of, and like I said,
So why did we bring it up? Why did you know why we brought it up, Brian? You're spot on. We brought it up because we sometimes operate in the security arena. And if you're a security director, or if you're a security guard, or if you're just a person that's attending one of these venues, you have to understand what the security posture is. And if the security posture is non-existent or low, you may invite an opportunity for that type of violence to occur, right? And so when you're sitting there, the things that Brian and I would caution you to think about is that your cyber threat is real. So go get a subject matter expert
right,
to handle that. That's not this case, but it's worth talking about. This case had nothing to do with Billy Counterman ever physically touching Coles Whalen.
right,
Yet, how the manner of alleged threats were delivered is huge. So consider that. The great thing, Brian, just like we tell everybody to go do a ride along because they're free, and any agency would glad to have you, you can go sit in on trials, unless the trial for some reason, whether it's a bench or a jury trial, unless there's some reason to exclude humans from it, the age of the offender, an undercover cop or testifying that, you can go and sit in a courtroom and take notes. And listen and be wowed by the legal system. So your security assessment and your priorities have to be thus. You have to prioritize. I just jotted this down quickly, so go bear with me. You have to prioritize what you really need protection of. Then you have to identify the gaps in that security posture, then train and implement stuff to do it. So the idea is, part of that is, you're going to go to the cop shop, and the cop is going to sit there and listen to the first few minutes of what you're saying and then say, yeah, it's not our jurisdiction, or that's a civil matter. Those are two things you're going to hear from every cop that you walk up and talk to. Brian, if you walk away at that point, you're making yourself a mistake. Ask for the supervisor. Shift supervisor comes out and say, hey, your officer says that it's not jurisdiction, but I have to have help because Billy Counterman is on my ass all the time, metaphorically, and I'm Coles Whalen, and I can't be bouncing around Colorado worrying about this guy. Then that shift supervisor says, lady, sounds like a civil problem. You go right across the street to the city attorney's office and go, what's going on here? I need protection. I'm asking for protection. Local cops aren't giving it. You see what I'm saying, Brian? Procedurally, in the security realm, you have to think about securing and filling those gaps and defenses. But when you're on the offensive, because you're the victim, you have to go, I'm not walking out of this office with the right answer. Do I need to get an attorney? Why would I have to get to retain an attorney to get Billy Counterman to stop what he's doing to me? You see what I'm saying? And you got to stick with it, because I'll tell you what, a lot of times the law enforcement and the courts aren't on your side unless you become the squeaky wheel. Why? Because it doesn't feel like a crime. And that's why we have to classify true threats, isn't it? Because, threatening behavior of this manner doesn't feel like a real crime. It'd be different if he slapped her. It'd be different if he made a box and made her think it was a bomb. You see how we think as humans, right?
That's the thing. It's because it's a subjective in nature. There's nothing subjective about one person hitting another person. Anyone sees that and goes, okay, yeah, I got it. That's a crime. That you can't do that. That's very, it's simple and it's easy to see and everyone knows. Right. But because there's some complexity in this with that subjective nature of these things. Well, look, you're kind of a popular singer. You're on social media all the time. You got to expect this stuff is going to happen. It's like, no, like, yes, I'm going to, but you that doesn't make it okay, or that doesn't change the dynamic.
Precisely.
And that's the issue that you see with a lot of these cases, especially the different stalking cases, different types of harassment stuff. I mean, because it's a seemingly gray area or it's seemingly subjective in nature, some people don't take it as seriously, or they don't think it's that big of a deal.
I agree.
And that happens. And then, like you said, you even brought it up too. Is there some people that, a loud noise startles me and forces me to stay inside my house for a week. So of course I'm feeling threatened when it's just the mailman showing up, literally dropping off my mail. Right. Well, so you have to put all that into place and go, all right, well, what in this context, what is this person feeling? What are they saying? What are they doing? What is the effect it has? What is the intended effect? And what is the actual effect? And what is the feeling effect? Like, what is the subjective effect?
You nailed something exactly. And I'll give you a companion caper for everybody that listens to us. If you're on this long, you know what we're talking about and you're interested. So New York recently sued Hyundai because their cars are too easy to steal.
Yeah.
So New York isn't solving the problem by saying it's wrong to steal a car. Do you understand what I'm saying here?
My God.
So Brian, this is a lens. This is the type of lens that we should ask the people that listen to our show to look through, because you don't deserve the type of behavior that's being bestowed upon you by another. And there should be a reasonable expectation in your life that you're not predated upon or stalked. And this is a perfect case to show that. And Brian, I think it's important, again, to remember, everybody, that what Brian said at the beginning is they're revisiting this question because the court has never spoken directly about this definition of threat behavior. And that's why it's so important to us, because like right now, everybody's going, oh, we should do away with the Supreme Court. Well, there you go. You might as well move
that's
to the worst place in the world and just give up all your rights.
I love the let's tear it all down crowd.
Yep. Isn't that great? We don't have anything to replace anything with, right?
We don't have a better idea.
Effing hammer. No,
it's like listening to a child. You know what I mean?
Yes.
It's like it's literally like
right when a child reasons. Well, that doesn't seem right.
Yeah, that's unfair.
I love the Sarah Silverman.
Times I got to tell the insurgent, she's like, that's not fair. I'm like,
exactly.
I know. You're right.
Sarah Silverman does this shtick where she goes, but I feel really strongly about it in my heart. So that's true. And that's science. And I always laugh because it's wonderful, because that's why we
Yeah,
caution people when we go into opinion-based testimony.
yeah. Well,
If I'm just giving you my take on events, then we're not doing a
your
360, Brian.
your New York Hyundai case is
It's
perfect.
perfect
It's
example. It's
perfect
a perfect
example of how
companion.
fucking stupid we are sometimes.
Yes,
And
yes,
I mean, really, that's absolutely insane. So it's one thing if you make a car that explodes when it gets in a car accident. Yeah,
yes,
you got to go after that car company. They
yes.
can't do. They're putting people in danger. But your car is too easy to steal,
Yep,
and that's your fault.
yep,
Fuck you. What the
exactly.
fuck does that even mean?
So
That's
then,
well, okay.
as
Well,
Sean
why?
Clemens would say, our consigliere, Brian, then let's sue TikTok, Instagram, and YouTube for putting out there when the people do steal those cars and
Yeah,
do the donuts and everything.
yeah.
Well, you know, you're advertising that, so clearly you're fomenting the theft. So we're going to sue you next. What?
No,
Where are
but
we
that's
going with
literally
that
like saying
extreme
I'm gonna press
logic?
charges at this on this guy who broke into my home and stole all
Yep.
my stuff, and then him going, "No, I think it's your this guy's house is just too easy to rob from. That's the
And it
problem."
said welcome on the welcome mat, and I'm
It
suing his
said right
ass.
there. It says welcome on the mat. So
I have
why,
the mat. I
like,
stole it too.
I stole that too.
Exactly.
So
You know, I've got that. I got it rolled up like a big joint in the
it's so
corner.
dumb. Now
How
if
stupid.
they want to go, all right, this is a problem. We need to write federal legislation that
Yes.
requires automakers to meet a certain standard going forward or something. That makes sense. They can do that. The
Yep.
government can do that, and it's literally like
But who does that?
it's
That's now
consumer
to
safety or it's
Congress, right?
but
You know, in
that's in our
OSHA
best
and
interest
exactly.
of the citizens of the United States to say, well, you need to meet this certain standard
So
because this is a growing problem. That makes sense. But to
exactly.
just sue them and say your car is
So
too easy to steal,
why do
that's
we
the
love
dumbest shit.
NTSB, Brian? It's ridiculous. Why do we love NTSB?
Yeah,
Because they're prudent.
yeah,
They they take time and they come out with good rulings. So we go to NTSB and we go, the seats aren't big enough on airplanes. And we're not talking comfort, we're talking physiology and psychology. And sooner or later, sociology on a plane is going to get somebody killed. That's been our argument for a couple of years now,
yeah.
that the
The,
raised elevated tensions. Now, the airline industry has countered that the second that there's a threat, they land the plane and they let the people off the plane come on and handle it, right? So that's a mitigation strategy, but it's not going to work long term, Brian,
no.
because what's going to happen is the seats are
Well,
going to get smaller, the tensions are going to get higher, and finally somebody's going to go, "You're ruining my flight to England, so I'm going to beat you," and that beating or the fall that's
yeah,
accompanying it
is
is
gonna
going to result in the
or
death.
the person stepping in to try and help is gonna end up
Yes.
killing
So
someone.
so that's how the law works slowly to get us there, where the NTSB would come up and go, if you don't change the size of these seats, there's going to be an incident. You see? So we
Yeah,
love that proactive, predictive nature of NTSB and how they look at these things and how they're going to happen, rather than where you have to establish law and a law has to be broken to go back and charge
well,
somebody. It's
because
way too late.
they're one of the
You know,
few investigatory bodies that say, okay, here's everything what happened. Here's all of the contributing factors. So
yes,
here's what you need to address going forward. This is what needs to be
yep,
changed. You have to change this flight training for this specific aircraft because we know this happens. We have to replace this part. You can no longer do that. There's going to be an additional inspection, and so they're
exactly.
almost writing the here's the suggestions for the policies going forward that is being what that the industry is where it's
Yep,
so safe but it's so potentially dangerous because every time something happens
yep,
a lot of people die. They immediately have to adopt that, and that's it. But we don't do that with a lot of other investigations. Just, well, here's what happened. It's like, oh,
yep.
okay, but then what? Well, we know what happened. It's like, okay, but do we
I'll tell
change
you, we need to
that
take
going
a
forward?
book from NTSB when we're addressing corporate security, workplace violence, school
School
shootings,
shootings, yeah. Any
and
police officer
we
involved
can keep
shooting as
preaching to the
well.
choir.
Honestly,
Exactly.
if you took the NTSB approach, this would be a little bit more. I think people understand it a little bit better because
Yep.
then what do? They say these are all, yeah, this person made a bad decision here, but they were trained to make these three decisions, and that's the
Yep.
problem. So it's not so much them, it's the training
Yeah,
that
yeah,
they got. You know
and
what
we
I
have
mean?
to take the onus off too. Look,
Yeah,
flying is inherently dangerous. Why? It's called gravity. You see what I'm trying to say? So what we have to do is we have to look at police. Look, police carry guns on the outside of their uniform,
Yeah.
on their belt. Why? Because it's a dangerous task. And sometimes cops with those bullets are going to shoot people. So we got to stop saying that every time there's an officer involved shooting, that it's a bad thing. What we got to do is we got to take a look at it and we have to say, here's the things that made this a clean legal shooting. You get what I'm saying? And then notify humans so humans can look at it and judge it at face value. But
Right.
what is our judgment
Oh,
criteria now?
yeah.
The
Yeah.
age of the offender, the number of shots, the
Yeah.
time it took. So, Brian, that's why I love NTSB2 because they give us a clear pattern, a clear timeline of events. They say it's this hexagonal boat at this time that failed, and that caused this reaction. That's the kind of thinking that we got to do. Science will get us out of any problem that we're in. Science, not all the rhetoric that we're seeing. And this is a perfect example, and that's why I'm so excited to see because Colorado did a great job of framing it. Now, I want to read that remark again because I think that's such a good one. The psychological effects of threatening behavior is frequently worse than the actual assault, and in this case, that perfectly epitomizes why we have to go after Billy Counterman. And
Yeah.
I don't mean him personally. I mean every Billy
Yeah.
Counterman
Yeah. Everyone.
on the face of the planet.
Yeah, absolutely. Okay, well, I think that's kind of a good place to sort of end on.
Yeah.
Again,
Oh my
if
God,
you're
what a big
listening,
discussion though,
I'll
Brian.
put all the
Good
links in the
call.
episode details. Go to the OEA website for any Supreme Court stuff you're
Yep.
looking at. They do such a good job. They give you all the stuff of the case right up front to look at, and then you can listen to the arguments if they've had arguments already. And now, because of all the AI stuff, you can get little transcripts. You can highlight, cut, clip, and all that stuff out. So it's really, really cool.
Yep.
And if you haven't listened to an argument, or if you haven't listened to an argument in front of the Supreme Court, it's great because
Incredible.
it's interesting, it's sort of clinical, and when they reference past cases, which is what you have to do in these, right? You have to have the precedent. They give this very bullet point view of it, so it's not this long rhetorical story. It's here's why I think this falls under. Here's what that means, and then the justice might step in. So, well, but wait a minute, in that case that was decided this. How does that apply to this case? And
Yep.
so they really do a cool job because then you can go back and look at all those and what they thought. But they're just so super interesting to listen to, and I love. I mean, if you're if you're a nerd like
We
me,
get hooked on it.
get
You
into
can
it. Yeah.
exactly. We're
So,
law nerds. We really
yeah,
are.
but
We love it.
because its stuff is so interesting how it plays
Yeah,
out,
it
and
is.
you hear some great arguments. So, all right, well
And there's probably
that's
another podcast that's talking about gallbladders and medicine. That ain't us. I mean, when it comes to that stuff, we don't
gallbladders
give a damn. Yeah,
and medicine.
some guy sitting there holding up a ventricle of the heart and everybody going ooh and ah. That's all cool shit. But I'm
Yeah.
telling you, the law is where it's at, folks.
All right. Well, on that note, um,
You're
check out our
such a
Patreon site.
where we do talk about gallbladders
Yeah,
this week.
so we're gonna get into some good ones on that. We've had some other cases on there and some
Yeah.
personal stuff that we do on the Patreon side, just to check out. You can actually sign up there now for a few days for free to check it out, and then decide if you want to. Now that's a new thing that they have on there, which is cool.
Wow.
But yeah, so you can hop on there and check out the other stuff that we do. We get into some of our either personal stories more and with some photos, or we talk about other cases in depth that we don't want to on here because we got to keep the chuds out of the comments as much as we
Yep.
can. So this is one way to do that. Although most of the comment actually type people, those chuds, they're not going to listen to a podcast like this because there's too much going on, and that would require them to come up with
Exactly.
some sort of
I have to have ammo to be a sniper.
yeah. But thanks to those who've reached out, continue reaching out.
Yeah.
Please leftofgreg@gmail.com. And don't forget that training changes behavior.